Iku Iluna, please rise. Ahea oko eko ka aha, inahe kuliana imua o kea aha ho o kolo kolo ki iki hano hano o ka moko ana o Hawaii. E nai mai, e malio mai, I lohi ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho ilalo, please be seated.
All right, please call the case.
Case number SCAP-24-0000079. Frederick A. Nitta, MD, Incorporated, et al., Plaintiffs' Appellees versus Hawaii Medical Service Association, Defendant Appellant. Arguing for the Defendant Appellant, Randall C. Watoff. Also appearing, Kamala S. Hockey. Arguing for Plaintiffs' Appellees, Ted H.S. Hong. Arguments on the merits.
All right, good morning. Aloha, everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you both ready to proceed?
Yes, sir.
Okay. Court's allocated 30 minutes for each side. And just to confirm, Mr. Wadoff, we're going to give you a warning light with 5 minutes to go, so you can reserve that time for rebuttal, correct?
Thank you.
Yeah. And Mr. Hong, we're going to give you a warning with 10 minutes to go in your argument. Very well. Mr. Wadoff, please proceed.
Mr. Chief Justice, and may it please the court. The trial court, in this case, committed reversible error when it relied on issues that had nothing to do with the party's dispute resolution provision to determine whether that clause was enforceable. Every appellate court that has considered that issue, including both this court and the United States Supreme Court, has held that the analysis must be limited to the arbitration provision itself. If the trial court had properly analyzed the arbitration provision in the parties' various agreements, it would have concluded that none of them were hidden or obscured. They do not favor one party over another. They do not unduly limit any party's ability to conduct the proceeding. And they were the product of negotiations between representatives for the plaintiff and HMSA. But not only did the trial court get this central question incorrect, it compounded its error by issuing an order that made conclusions that were wildly outside the scope of the motion presented to it. The trial court's order purports to resolve disputed issues of fact that go to the very heart of the case.
Counsel, could you raise your microphone, please? More toward your,
There you go.
thank you.
Thank you. The trial court's order purported to resolve disputed issues of fact that went to the heart of the case. These are issues that could not possibly be decided on a motion to compel arbitration. The motion that was before the court was purely to determine whether three specific parties, FNI, Mr. Norton, Ms. Orchino, would be compelled to arbitrate. It did not address challenges to the nature of health insurance or to whether these individuals received adequate medical treatment. Regardless of how the court rules on arbitration, these fundamental problems with the court's order must be corrected. Justices, there are three general areas I want to cover in my argument today. First, I will discuss the rule that prohibits the consideration of contractual clauses outside of the arbitration provision on a motion to compel arbitration. Second, I will explain how each of the 5 agreements at issue in this case pass Hawaii's test for conscionability. And third, I want to highlight some of the plainly improper substantive conclusions that were included in the court's order.
Mr. Wadoff, just before you embark on that, you said something in your opening remarking about representatives of the plaintiffs and HMSA negotiated. Can you explain in what sense who those representatives were and in what sense there was negotiation on these provisions or contracts?
I can, Your Honor. Now, to do that, I'll need to go through the various agreements that are at issue here. There's 5 agreements that are in total.
You can summarize or pick one or two. Give us, representatives. Who are you talking about?
Thank you, Your Honor. With respect to FNI, the provider that was at issue here, there were three agreements that are at issue in this case. Those provider agreements are agreements that are regularly updated over the course of a provider providing services to HMSA. They get renegotiated, updated, revised approximately every 3 years. As part of that process, what HMSA does is it communicates directly with the Hawaii Medical Association, the largest entity representing health providers in Hawaii, to discuss those revisions and those changes to its provider agreements. It provides HMA with a copy of the agreement, and it has discussions with individuals at HMA about their views on that agreement, potential changes to the agreement, how that agreement can be structured.
But HMA represents doctors across the state, physicians across the state, correct?
Correct, Your Honor.
Including physicians who may have wildly different points of view about insurance coverage issues, the role of HMSA, and the like, correct?
That's correct, Your Honor.
So in what sense is HMA representing Dr. Nitta in those discussions?
So HMA is just the first phase of this process, Your Honor. In addition to HMA, after that review takes place, and as Your Honors probably saw from HMA's amicus brief, HMSA takes that process seriously and often incorporates provisions from HMA. Then the agreements are sent to all of the providers that are potentially going to be parties to that agreement. That includes FNI itself, the party in this case. It receives not just a copy of the draft agreement, but a bullet point list of the changes that are contemplated for that year's agreement, and it receives a special form that allows providers like FNI and all of the other providers that are potentially going to sign on to this to provide comments and feedback back on this agreement. So phase one is review by HMA, which is looking out for all providers across the state. Phase two is that these agreements are sent to all of the providers so that they can provide specific input about how it might impact them.
Okay, but there was a attachment from Dr. Nitta. He actually went down. He asked to discuss this arbitration clause, and they said, too bad, too sad, basically. And they said it's non-negotiable. How do you square that with what you just said?
So there's two times when Mr. Nitta attempted to provide feedback on this agreement. Now, one thing I want to kind of highlight is the agreement that we're talking about at issue in this case is the 2020 agreement. That's when these claims at issue arose, and those are the agreement that would be covered here. And in connection with that 2020 agreement, Mr. Nitta did provide comments to the proposed agreement.
Dr. Nitta, right?
I'm sorry. Thank you, Your Honor. Dr. Nitta. I apologize. Dr. Nitta did provide comments back to that agreement, but it did so after the time period to comment on the agreement had already expired. So this is a massive undertaking that HMSA undergoes to send these agreements to all potential providers throughout the state. Because of that, it has to have requirements on when individuals will respond, how it will incorporate and address those comments.
I'm sorry.
Oh, I'm sorry.
Please proceed.
Oh.
Please finish.
Here, Dr. Nitta responded after that time period had already expired. Second, the comments that he provided back to the agreement were in large part nonsensical. They included words that had been struck out that didn't make any sense in the context of the agreement. The substantive changes that he made were changes that no party would ever agree to in the context of an arbitration provision. For instance, he changed the arbitration provision so that it would only be binding on HMSA and not binding on FNI. No party would ever agree to an arbitration where the results are only binding on one party. So while FNI submitted comments on this document, they were not comments that were
Which document?
the 2020 provider agreement.
Okay. So in terms of the 2020 provider agreement, is that docket 143 what you attached to?
I think it's attached in two areas, Your Honor.
Right.
I believe there's one version around docket 143, which is an excerpt that includes the arbitration provision.
Right.
And then I believe around docket 201, 202, there's a full version of the 2020 agreement.
Okay. All right. So that 200 or 202. Thank you.
Yeah, and Your Honor, after the break, I'd be happy to give you the specific docket number.
Thank you.
So while it's correct that Dr. Nitta provided comments back, HMSA has to address these agreements on a large scale. It has to have agreements that are consistent throughout its provider base. And that's because HMSA enters into these agreements with hundreds, if not thousands, of providers. And in this context, consistency is critical. HMSA is not entering into standardized agreements because it's trying to foist inappropriate terms onto providers. It's not trying to enter into standardized agreements so it can give itself an unfair advantage. It needs a standardized agreement so that the various providers that are throughout the state are treated consistently, and so that it can treat them in a way that allows administrative costs to be managed. If there wasn't consistency amongst the agreements, the administrative costs with administering these agreements would be significantly more expensive.
In 2020, how many amendments were made by HMSA in response to comments from the providers, the hundreds or thousands of providers? Do you know?
I do not know that information. I can say, Your Honor, that these documents went out to all of the providers and that we specifically have submitted the version that went out to FNI to show that FNI did receive the draft agreement and the ability to comment prior to the deadline.
You know, it does seem like this is a take it or leave it, situation, contract drafted by a stronger party. I understand your position that, look, we have all these physicians. It's tough to get any type of consensus. You engage in your process. But, when I guess the substantive terms affect the public health, the public welfare, do we need, I guess, a more heightened scrutiny to the initial contract formulation?
No court has ever established that, Your Honor. But even if there was heightened scrutiny here, I mean, there's always two parts to the conscionability analysis. There's procedural unconscionability, and there's substantive unconscionability. And it sounds like what Your Honor is suggesting is whether there's a heightened substantive unconscionability analysis for this type of agreement. And I guess I'll address that momentarily, but the final point I want to make about procedural conscionability here is that many courts have noted that there's nothing good or inherently bad about standardized agreements like this. They're a fact of our modern life. If we're going to have entities that are providing health care throughout the state, they need to be able to rely on consistent agreements. And so there's nothing inherently negative about this process.
And I get that position. But, we're talking about, I guess, unique interests here, protecting consumers, the doctor-patient relationship, things of that nature. And when you say no court has done this, I mean, we're really looking at sort of the federal framework. And I'm wondering if, since this is contract law, when push comes to shove, that really, do we have the opportunity here in addressing the common law in our state to expand unconscionability beyond the federal standard?
Your Honor, I do not believe that exists here, Your Honor. This court does not have the ability to establish a different standard of unconscionability that would apply to one set of agreements and that would apply to another set of agreements. But I would submit, Your Honor, that we don't need to go down that road in this situation, because under any analysis of the arbitration provision that is at issue in this case, it would pass the test for conscionability.
Well, are these contracts, does the Federal Arbitration Act apply to them?
It does, Your Honor.
And I'm sorry, let me just follow up on that. That was going to be my next question. What is the impact of preemption here?
So thank you, Your Honor. And I would direct Your Honors to, I think the case is Lee v. Heftel. That's a Hawaii Supreme Court case. But in addition, the Buckeye check cashing case, which we cited in our brief, Buckeye directly held that under the FAA, the rule that prohibits courts from considering provisions outside of the arbitration provision That applies not just to federal courts, but that applies to state courts and to state claims as well. It recognized that under the FAA, there's a limited body of substantive law that has been created and that has been applied not just by the Buckeye check cashing case, but the Prima Paint case, and which has been recognized in a number of Hawaii Supreme Court cases, not just Lee v. Heftel, but I believe also the Brown v. KFC case and a number of other cases have recognized that the Federal Arbitration Act, that substantive body of law will apply here. And so respectfully, I believe that would prohibit this court from establishing new rules that are outside of that.
Putting aside new rules, as you've indicated, under the FAA cases there and Buckeye, there is still a place for state law on these issues, right? So this court has clearly held that punitive damages exclusions are unenforceable, invalid. Why do you continue to include that in your physician agreement?
Your Honor, I do not believe that this court has held that a punitive damages exclusion standing by itself is sufficient to invalidate an arbitration provision.
But why do you include a clause that we've said is invalid?
Respectfully, Your Honor, I don't believe that the court has determined that clause by itself is invalid. But to the extent that
Narayan, please take a look at our Narayan opinion.
I will, Your Honor, thank you. I do believe that Narayan had significantly different facts here, that where the provision in that case was not just one that prohibited punitive damages, but also had significant limitations on the type of discovery and other elements that would have impacted the arbitration proceedings. But putting that aside for a second, Your Honor, I think that if Your Honor believes that the punitive damages limitation, which only exists in one of the 5 agreements that are at issue here, that under Narayan, that provision would clearly be severable if the court has concerns about that provision. That this is not a situation like Narayan, where there was a number of significant problems with respect to the arbitration provision that was at issue. This is a situation where the only agreement that contains that provision and has that clause in a single sentence, and it also has no other significant limitations on the party's ability to litigate this case.
All right, in terms of the party's ability to litigate this case, I do not see the motion, your motion to compel, having been filed against the Hawaii County Medical Association. Is that correct?
I'm sorry.
Did your motion intend to compel arbitration against HCMA?
It did not move to compel arbitration against HCMA.
So in other words, HCMA, you are conceding, is free to litigate based on our HMA opinion.
I think there's some very significant problems with respect to HCMA submitting a claim in this case, but we would agree that based on your HMA decision, that it would not be bound by the arbitration provision that exists in this in any of the 5 issues agreements that are at issue here, Your Honor.
Because I noticed your motion said stay the litigation pending arbitration. I was assuming that pertained to HCMA's claims?
That's correct, Your Honor.
All right.
And what's different about all of the other claims in this case and separates it from the HMA case is that all of the claims in this case really relate to the provision of specific medical services. This is a situation where FNI is asserting claims that certain patients should have received certain specific medical treatments. This is a situation where Mr. Norton claims that he should have been entitled to an MRI under the provisions of his guide to benefits. And
But one of the challenges is with respect to the arbitration clauses themselves, correct? Like generally.
That's correct, Your Honor. And I guess the point I'm just trying to make here is, I think in HMA, the court sort of distinguished claims that are unrelated to specific medical issues and specific medical coverage determinations. And so I just wanted to emphasize that the claims of FNI, Mr. Norton, and Ms. Orchino do not fall into that category, Your Honor.
Mr. Wano, just to put a lot of this in context, the claims cover tort claims, RICO claims, the DEC action claims. What's really before our court simply is, should those claims be arbitrated, right? I mean, that's the only thing, I think in my view, we have appellate jurisdiction over. That's the basis for the appeal under Chapter 658A, correct?
That's absolutely correct, Your Honor. We
Okay.
view this as a relatively simple question that's before the court. And it's,
What happened at the circuit court was beyond just the question of arbitrability, the court then addressed unconscionability of the 5 agreements, or at least 3 of the agreements, I should say, not 5, but 3 of the agreements. Is that right? And held that they were unconscionable and unenforceable.
that's what was stated in the order, Your Honor. And if I can be blunt about this order, essentially what happened is a order was submitted to the court and it was rubber stamped without any revisions from the trial court judge. And because of that, it included a number of provisions that had nothing to do with the issues that were before the court. And there's no need for this court to do this, but just a comparison between the order that the court issued and the transcripts of the hearings indicate that none of these issues were ones that were litigated in this case.
If I understand your position with regards to whether the motion to compel arbitration should have been denied, which is what happened below, your main position is the arguments were as to the agreements as a whole, as opposed to just the arbitration provision being unconscionable, which is what the federal law in your position requires.
That's correct, Your Honor. And I would emphasize, too, that it's not just the federal law that requires that in this scenario. Levy, Heftel, and a number of other Hawaii Supreme Court cases have already recognized that an arbitration provision is severable from its overall agreement, and that when analyzing whether to compel arbitration, the court is required to look at that arbitration in a vacuum.
Do you agree that with regards to not Mr. Norton, but the other Miss Orsino, her agreement does not have an arbitration provision? Is that correct?
That's correct, Your Honor. So the motion was a little bit unique in that with respect to Miss Orsino, we sought summary judgment on that particular claim.
You saw dismissal, right?
Correct, Your Honor. And the reason—
Instead of a stay.
I'm sorry?
Instead of a stay of her claims.
That's correct. And our position there is that because she's a MedQuest member, there's a specific Hawaii administrative rule that establishes an administrative process for resolving those issues. And so we are not asserting that she should be compelled to arbitrate, just that she should be compelled, if she would like to do so, to follow the state-mandated rules for pursuing a claim in connection with a MedQuest.
All right, thank you.
In terms of examining the arbitration clause itself, the court can determine unconscionability, correct?
It can, Your Honor.
And it is for the court to determine unconscionability.
It is, Your Honor.
And you're saying that you look at procedural and substantive.
I believe that, as Your Honor pointed out, Narayan clearly establishes that we must look at both procedural and substantive unconscionability when doing that examination.
I have a specific question with respect to the Quest participating physician agreement. I noticed that the regular HMSA provider agreement does allow, I believe, the arbitrator to determine who pays the arbitrator's fee, I believe, I'm not sure. But the Quest agreement says both parties shall share the arbitrator's fee equally. So you're saying that if a Quest participating physician contests a $100 claim, they have to share the arbitrator's $400 an hour arbitration fee equally.
With respect to providers, that is what the agreement specifies, Your Honor.
How is that not unconscionable, substantively unconscionable?
Your Honor, that's a feature of many arbitration provisions. And as far as I'm aware, no court has ever held that a business like FNI cannot be required to participate in the costs of an arbitration proceeding. Isn't
that really chilling? Who's going to bring claims for a $50 payment or $100 into these small disputes, right? For Quest payments?
So, Your Honor, that's why there's as Your Honor probably saw, there's a very detailed process that parties can pursue in connection with challenging a claim. And so arbitration is really the last step where other challenges have already failed and we haven't been able to reach a resolution
But
amongst the
your
parties.
motion sought to compel arbitration. I didn't see your motion saying that they failed to exhaust these remedies first.
So actually, Your Honor, we filed a motion to dismiss earlier in this case, making essentially that argument. And Judge Kim advised that he viewed this as really a motion to compel arbitration situation. And so that's why we thereafter filed a motion to compel arbitration.
But you didn't appeal that decision. You didn't appeal. I don't see as a part of your appeal a claim that any of the plaintiffs failed to exhaust, Ms. Orsino, administrative remedies, but in terms of the others, I don't see a claim that, we shouldn't even be at the arbitration stage because they failed to do the independent review or internal or other ways of appealing administratively.
Your Honor, the way that I view this is that because we cannot take a intervening appeal of that motion to dismiss without express permission from the court and this court accepting it, we are at this stage of the case essentially required to accept the lower court's ruling on that issue that remedies have been exhausted by its denial of our motion to dismiss. So because that was established by the trial court and we're up before Your Honors purely on an issue of a motion to compel arbitration, we are sort of stuck with that decision in the present procedural posture. That's my understanding, Your Honor.
I see. So the issue might be preserved.
That we would reserve our rights on that, Your Honor. And ultimately, our position here is that this type of situation is exactly why arbitration and alternative dispute resolution exists. Healthcare decisions are decisions where we need fast, efficient resolutions. We need ways to get to decisions that aren't going to be exorbitantly expensive. We need ways to get to quick decisions so that individuals know what specific health care they're going to be entitled to. And so that's why there is this process outlined in all of the agreements where parties can take informal appeals with respect to HMA itself, with respect to individual members. There's entities that they can go to for independent review of their medical claims as well. And then when finally needed, there is an ability to go to arbitration and get a resolution much more quickly than they would be able to get a resolution in state court. And I will point out, Your Honor, that with respect to the individual members, such as Mr. Norton, in that agreement, the agreement expressly specifies that HMSA is responsible for all costs associated with the arbitration. So when it comes to members, when it comes to individuals, HMSA takes on all of the cost of that arbitration process. It's only when it's arbitrating against another business that the costs are shared between the parties.
But those processes you just detailed, I mean, one of them is, and it kind of gets to the substantive unconscionability, where HMSA unilaterally decides who the arbitrator is. In other words, the home team is picking the ref, and the ref might not call any more games if the ref rules against HMSA, and that's why I'm simply wondering, when we talk about procedural and substantive unconscionability, I mean, how is that not substantively unconscionable? And I understand your processes, and we have to do it that way, but why the unilateral selection of arbitrators?
Respectfully, Your Honor, and while I'm sitting down, I'll go back through the agreements again, but I don't believe any of the agreements give HMSA the unilateral abilities to select arbitrators. All of the agreements specify that the arbitrators will be jointly agreed to by the parties, and if the parties can't agree to a joint arbitrator, then it will be picked pursuant to either dispute prevention and resolutions processes, which have a
Okay, I got you. Sorry if I misunderstood that.
So in all instances, Your Honor, there is a way to select arbitrators that does not give one party the ability to control.
Can I ask you on that one point? You're talking about consistency with the agreements and so on. And with the physician agreement, it talks about arbitration, but then it says that you may request arbitration, whereas the Quest agreement and the Medicare says you shall. Isn't there some ambiguity in the physician agreement specifically to that arbitration clause?
I don't think so, Your Honor. I think that
it says may. The others say shall.
So when read in the context of the overall agreement, I think that it's clear that your option is to pursue arbitration if you are going to challenge the specific types of issues that are covered by that arbitration clause. Not everyone will pursue arbitration. There's other ways, informal ways to resolve these cases. There's an internal appeal process. There's other ways to address these sorts of issues. But to the extent that the party is going to seek a litigated resolution of it, that commercial provider agreement does require arbitration.
Do you agree? I'm sorry, please.
Mr. Wada, what about the tort claims that are articulated in the amended complaint? Are they covered by the requirement to arbitrate in your view? I'm looking at the Yogi and HMA cases and wondering whether the agreements at issue here are sufficient to reach tort theories as well as contractual theories.
Absolutely, Your Honor. This court has ruled that language, the arising under language that is included in these arbitration clause is broad language that encompasses both contractual and tort claims that are nevertheless related to the contract. And I think that
But
while
Unidev didn't discuss HMA or Yogi.
I'm sorry, Your Honor?
Our Unidev opinion did not address HMA or Yogi, did not overrule those cases, so aren't they still good law?
They are definitely still good law, Your Honor. That rule that tort and equitable claims and even statutory claims can be subject to arbitration provisions is universally recognized, not just by Hawaii, but as far as I'm aware, every state that has considered that issue. And the reason for it is that if we didn't have that rule, then careful pleading would allow a party to avoid an arbitration provision in almost any situation. A good lawyer is always going to find a way to plead a contract claim as a tort claim. And I think, Your Honor, that's exactly what's happened here. We've had claims that have been characterized as tort claims, but if you actually look at the pleading, if you look at what is being alleged here, it's that HMSA allegedly did not provide benefits that it was required to provide under its benefits agreement. And allowing an individual to just kind of frame that as a tort claim would totally defeat the arbitration provision itself.
One more question. We review arbitrability de novo, correct?
You do, Your Honor.
And so, and the courts determine unconscionability. Is that correct?
That is correct, Your Honor.
So this court could address aspects of procedural and or substantive unconscionability without deciding all of them. Would you agree with that?
I would agree, Your Honor. The only limitation that I would suggest that I believe still applies is they would have to be issues that were nevertheless raised by the parties below. That there's any number of arguments that were not raised here and that were waived and not briefed. But Your Honor can consider arguments raised in the lower court de novo and resolve them at this level.
And the courts generally decide arbitrability, except you've cited to the United States Supreme Court case in terms of the delegation provision, in terms of the one agreement that does have a provision that says that the arbitrator decides arbitrability.
That's correct, Your Honor. But we are not challenging the court's ability to determine arbitrability in this instance, Your Honor, despite that language that would be favorable to HMSA in this situation.
All right. Okay. Thank you.
Thank you.
All right, Mr. Wada, we went over your allotted time, but I will give you some time for rebuttal.
Thank you very much.
Thank you. Mr. Hong?
May it please the court. Chief Justice Reckenwald, Associate Justices, good morning. My name is Ted Hong. I represent the Appellees, Frederick A. Nitta, MD, Inc., and Frederick A. Nitta as an individual. Dr. Nitta is present in the gallery. I also represent the Hawaii County Medical Society, Charlene Orsino, and Adrian Scott Norton, who passed away, and his son Thor Norton is here this morning in the gallery monitoring for the proceedings. With the court's permission, and before I proceed, I certainly like to, as a matter of respect, recognize our former governor, Ben Cayetano, and his wife, Vicky Cayetano, who are in the gallery.
Very well. Thank you.
Thank you, Your Honor. We also like to thank the Amici for filing their briefs. We thought they brought very good issues or interesting issues to the court's attention. The three cases, Hawaii State Supreme Court cases that apply in this particular case that provide the framework for analysis are the Gabriel decision written by Justice McKenna in 2017, the Narayan case that came out a month later written by Justice Nakayama, and then in 2013, the Siopes case, if I'm mispronouncing that, I apologize, that was written by Justice Pollock in 2013. And in those cases, in Siopes at page 459, it specifically states that unconscionability is within the court's review whether a valid and enforceable agreement to arbitrate exists. And the court in all three cases cited the restatement second on contracts, section 208, which says, if a contract or terms is unconscionable, the court can A, refuse to enforce the contract, or 2, may enforce the remainder of the contract without the unconscionable term, or 3, limit the application of any unconscionable term to avoid any unconscionable result. That's the Gabriel case at page 341, the Narayan case at footnote 10, and the Siopes case at 459. The court has said in Gabriel and Narayan, at page Gabriel at 340 and 341, the Narayan case at 356, the court can refuse to enforce the contract under 3 circumstances. Unconscionability is central or pervades the contract. There's serious moral turpitude, where Justice McKenna was citing the beneficial case, and it's prohibited by statute. And unconscionability in this case, as we had pointed out at the lower court, is central and pervades these HMSA contracts. Let me start with procedural unconscionability.
Mr. Hung, what's your response to the argument we should only be looking at the clause, the actual arbitration clause, before we get into the bigger contract? Because that's sort of the core of Mr. Wadoff's argument. And is that the argument you're making about the restatement, that's your basis for looking at the entire relationship as reflected in the contract? Or how do we get beyond just the arbitration clauses themselves?
If the court, my argument is that if there's a banana and part of it is rotten, Mr. Wadoff is saying you cut off the rotten part and eat the rest. My whole point of view in this particular case from the beginning is that the entire banana has to go out the door. It has to go into the trash. It's rotten. We're suggesting that all 3 HMSA contracts with the providers are unconscionable, procedurally and substantively, and should be thrown out.
Counsel, if I can ask you, what is your argument as to the arbitration clause alone as to being substantively unconscionable?
It is substantively unconscionable, but as I pointed out, we're looking at that is a reflection of a larger unconscionable contract. Because when you look at, for example, the provider agreement at docket 143, the Medicaid provider agreement at docket 144, or the Quest document contract at 145, docket 145, it's all about payment to the provider. It's all about minimizing HMSA's reimbursement or trying to diffuse that decision-making and to the disadvantage of the providers. The arbitration clause is just a symptom of a larger illness, we feel, with respect to these contracts. And that's why—
The problem, though, Mr. Hong, with your position is that under the law, the Federal Arbitration Act does apply to these contracts. We must apply what the United States Supreme Court has said with respect to the Buckeye case is pretty clear that unless the challenge is to the arbitration clause itself, the issue of the contract's validity is to be considered by the arbitrator in the first instance, if there is a valid arbitration clause. So this court can only look at the arbitration clause in terms of determining procedural and or substantive unconscionability at this point, I believe, under the law.
With all due respect, I disagree with you. And the reason is that in docket 143 and docket 145, HMSA specifically states in 143 that they are adopting 658A of the Hawaii Uniform Arbitration Act in terms of any arbitration. In 145, they say that in terms of the controlling law, the laws of the state of Hawaii apply. So in your decision in Gabriel, you said at page 334, the FAA does not preempt state appeals provisions regarding enforceability of an arbitration agreement. And what we're trying to say this morning is that with respect to any arbitration agreement, that is just, again, a symptom that infects or is a symptom of a larger illness or certainly unfair contract. I would point out that in the Narayan opinion at page 350, Justice Nakayama quotes the Renda Center, which is a United States Supreme Court case, and I'll read it specifically. Quote, specifically, arbitration agreements, like all other contracts, may be invalidated by generally applicable contract defenses, such as fraud, duress, or unconscionability. So we're suggesting to you, and we submit to the court, that these contracts are completely unconscionable and should be thrown out, not necessarily with these arbitration clauses. I'm sorry, Justice Edmonds.
Well, again, their point, HMSA's point, is this is just simply a motion to compel arbitration, and you're treading into a whole different lane. So can you clarify to us why we should go into that lane that you want us to go into?
I don't see this as a lane, as I think it's just part of this, the super freeway or super highway, I-5, and we're all going in the same direction. And the reason why I say that, Justice Edmonds, is because you cannot divorce the lopsidedness, the one-sidedness that you see in these arbitration agreements, and it is a reflection of the larger contracts with these providers that HMSA forces upon the providers. And I would point out, in terms of Justice Devons's question regarding the negotiability, for example, we provided at docket 223, PDF pages 9 through 10. This is a recording from the provider operations person in HMSA, where she says, in terms of the contracts and my client's willingness to negotiate, quote, so they are a standard agreements that everyone signs, end quote. And on PDF page 10 of the same document, she states that the old contract is the same as the new contract. They just keep recycling these unconscionable contracts. There is no negotiation. My client specifically said he wanted to negotiate the hold harmless clause, the arbitration clause. And just because a party's demands, and you've been there in settlement conferences too, where one party is, light years away from what reality is, you start there and say, okay, that's fine, you're here, but let's start talking about reality, and you start negotiating. But there's none of that. It's a standard contract. You either you take it or leave it. And that's specifically out of the mouth of an HMSA representative. And that's why we feel that with respect to not only the arbitration clause, but the clause of the entire contracts, that these are unconscionable.
Mr. Hong, focusing still on the arbitration clause, in what ways is it procedurally or substantively unconscionable, or the arbitration clauses?
So in the Narayan case, Justice Nakayama characterized procedural unconscionability as a lack of meaningful choice, a take it or leave it type of contract. As we had pointed out at docket 223, PDF pages 9 and 10, that there was no negotiation in terms of the contract language. Ms. Krause, the provider's operation representative from HMSA, specifically said that. And we would submit that in terms of the other declarations submitted by doctors throughout the state of Hawaii, from Kauai all the way down to the Big Island and everywhere in between, we have 17 healthcare providers from different areas of the healthcare industry or profession who have all said that they have tried on a number of occasions to negotiate the language, even the reimbursement with HMSA.
But what about Leong versus Takasaki?
I would go back to your concurring opinion, and I think it was in the Seopsis case, where you stated that you would actually, on the issue of mutual consent, reverse the Leong decision, and I agree with you. And I hope that any decision coming out here, that's reflected.
Because Leong versus Takasaki did fairly clearly say that, the Public Health Fund, now the UTF, negotiates, and that was Kaiser, I believe, but, negotiates with the health insurance company, and it's not an adhesion contract, right? So we would need to overrule Leong versus Takasaki to reach the decision that position that you're taking, correct?
Yes, and I suggest this is the time to actually do this. This case presents you with the opportunity to do that. And the court said, and I believe it was in the Ciopsis case, where you use the EUTF or the agency issue of kind of basically whitewashing or trying to somehow diffuse some kind of accountability or responsibility for unconscionable terms when you're washing it through the EUTF and other unions, that was no longer applicable, that the agency issue was no longer applicable.
So, Mr. Hong, on your side, you have 17 docs and a bunch of folks who are saying HMSA never negotiates.
That's correct, Your Honor.
HMSA says, well, we talked to the Hawaii Medical Association, take their input, send the contracts out to everybody, listen to input. And by the way, Dr. Nitta didn't get his input back in a timely manner. Is that a dispute of fact, or is that something that, how is that supposed to be resolved? In other words, is that as a matter of law, you would ask us to say the process of consulting with the Hawaii Medical Association and sending copies out for comment is not enough, not a meaningful negotiation, or is more discovery needed, or how do we get to the bottom of that?
There are two things I'd like to point out in response to your question, Chief Justice. The first is that there is a fundamental difference between standing here in the well and speaking to the court about what the record may reflect or doesn't reflect, and that is fundamentally different from what the record actually reflects. A lot of the statements made previously, I feel, are not supported in the record on appeal. So, for example, in terms of this process that goes out, one of the critical issues that appears in all the contracts with the providers is that HMSA is under the has the exclusive control over payment criteria. They get to control it. They get to identify what those costs are going to be. They get to identify what the factors are going to be that would dictate to have my client or any other doctor reimbursed or paid. They control that issue. They do that exclusively. They don't get the input of anybody else.
But again, you are asking us to visit the issue of whether or the entire contract instead of just the arbitration clause. And earlier you argued that because the contracts say that they're going to be governed by Chapter 658A, the Hawaii law, the law pursuant to the FAA saying that we can only visit the arbitration clause is not applicable. But we recognized in Narayan that the FAA creates a body of federal substantive law of arbitrability, enforceable in both state and federal courts, and preempting any state laws or policies to the contrary. So we do have to limit ourselves to what the United States Supreme Court says in terms of how we view these contracts.
And I would certainly go back again to your decision in Gabriel at page 334, which you state that the FAA doesn't preempt certain state appeals provisions with respect to examining arbitration agreements.
Right. Okay.
Well, so come back to my question in the context of the arbitration clause. So on one hand, I think you would argue you have enough evidence to suggest HMSA never meaningfully discusses the arbitration clause, and HMSA says, well, we consult with the Hawaii Medical Association and we send all of these agreements out for comment and we listen to those comments. So how are we supposed to get to the bottom of that dispute? Or is it what do we do? Is that something we make the call, or we need more discovery, or how is that sorted out? And then I'll get to this other part, the substantive unconscionability, in a minute.
And I appreciate you refocusing my attention on that particular issue. My point in bringing out what is in the record versus what is being argued goes precisely to your point. I do not believe that process in terms of admissible evidence is anywhere in the record on appeal. That the process that they described and was answering your questions about how they work things, I mean, part of that appears in the record, but it does not in its totality appear in the record on appeal. And I would encourage the court, as it's looking at this difficult case, to look at the record on appeal, because I do not believe that that statement can be supported. And so the court does have before it enough information to make a decision.
as to whether there's meaningful negotiation on that clause.
Yes, Your Honor.
Okay. Now, what about on the other side? Is the clause stacked in favor of HMSA, and if so, how? Improperly stacked in favor of HMSA, and if so, how? We had some discussion about whether HMSA picks the arbitrator or not. At least one of the provisions I looked at, it seems like it's a process that's ultimately delegated to dispute resolution and prevention, and there's sort of like parties can mutually agree, and if not, there's a process to ultimately identify the arbitrator. Am I reading that wrong, or is it different in the different contracts? And is there another area you'd like to focus on?
Thank you, Your Honor. So that language appears in docket 143, I believe, which is the physician provider agreement with Dr. Nitta and FNI. It does not appear, and I would point out that that language does not appear in 143, excuse me. No, I'm getting the docket mixed up. I apologize. So it doesn't appear in the Quest Provider Agreement, which I believe is docket 145. It doesn't appear in 144, which is the Medicare Provider Agreement. That language only shows up, I believe, in docket 143, which is the physician-provider agreement. So when we look at the totality of the circumstances, why we're here this morning is to suggest that because of the inconsistencies that the court pointed out in all these different documents, that these documents or at least these three contracts are unconscionable.
But why if the provider agreement allows a fair process to select the arbitrator, how is that one tainted by any unconscionability in the other two agreements? Because that's what I understood you're saying. Like, you know, maybe the provider agreement between HMSA and the doctor or the doctor's company it provides for a fair selection process, but that process doesn't exist in the Quest or Medicare agreement. So all three of them are bad. That's what I thought I heard you say. But if you could articulate why is it problematic? Why is the process in the provider agreement that with Dr. Nitta or his company sign in firm?
We feel that that's unfair because he did not have the opportunity to negotiate. When we had pointed out earlier that he wanted to negotiate the arbitration agreement, and I think that was record on appeal at docket 223, pages 9 and 10, where he's engaging with the HMSA provider operations representative saying, hey, let me negotiate these terms and conditions, and they refuse. That's why we feel it's unconscionable. That's why we feel it's indicative that all these agreements, these three different agreements, are unconscionable.
Very well.
Counsel, was it established that Mr. Norton's plan was a government plan?
Yes, he was covered under his wife's plan, and she was, I believe, a DOE employee at the time.
Thank you.
What's your response to Mr. Wadoff's argument that in order to have a functioning healthcare system, HMSA really can't entertain a lot of variation in the agreements it has with the tens of, thousands probably of providers who it works with?
And I submit that's hyperbole. I submit that's a parade of horribles that doesn't apply. And I'm going to give you two examples. In another lifetime, you were the head of the Department of Commerce and Consumer Affairs, Chief Justice. You actually moved the entire department from the building it was in to a different building. Nobody said, I heard nobody in the state government say, oh yeah, no problem, he can do it. I heard every reason in the world that it couldn't be done, and you did it. In terms of contracts, I've been participating in negotiating big contracts with the largest public employees unions in the state. And you start small, go with the low-hanging fruit, and then you work on different, more controversial topics. My point is, for them to say that is ridiculous. All it takes are motivated people who actually want to negotiate in terms of what the terms and conditions are. You just got to sit down and do it. But they don't want to do it. This is a multi-billion-dollar industry that controls, a lot of bureaucrats throughout the state of Hawaii. You have clerks now making decisions, like in Mr. Norton's case, that he doesn't need an MRI, that he only has to do more physical therapy. And Thor will be able to tell you that he drove his dad to all these appointments, and his dad was in physical pain, and that unimaginable physical pain. It was like going through torture. But these are decisions that HMSA says they can't make those calls. It has to be one uniform. It has to be vanilla for everybody. But that's not true. Doctors are highly intelligent and highly educated. They can negotiate their contracts. It's just a matter of HMSA willing to do that. And right now, because of the imbalance of the situation, a doctor in Waimea on the Big Island, a doctor on Kauai, they can't do that. They can't negotiate with HMSA. And HMSA, take them at their word. You look at docket 223, take them at their word. They're not going to negotiate what they feel are standardized contracts.
You know, it's interesting to me, Mr. Hong, what you're arguing goes back and forth between specific claims for treatment, right? Like with regards to Mr. Norton, and also Ms. Orsino. We understand what the circumstances were there, but those specific claims for treatment have their processes. You're not challenging those processes. You're challenging a larger scope of having Mr. Norton, Ms. Orsino, others, Dr. Nitta from the provider side, having experienced over time a variety of challenges with HMSA, that your clients are entitled to money damages as a result of that conduct, right? And that's the question, really. It's not as to those specific claims for treatment, it's whether your claims for money damages should go to an arbitrator or not, right? I mean, so I just want to make that clear, because I think there's a difference with regards to the claim for treatment as opposed to the tort and larger claims that I think are asserted in your third amended complaint here.
I appreciate what you're saying, Justice Ganoza. What I'm trying to say is HMSA creates a process of allegedly dispute resolution. But whether it's with the individuals like Ms. Orsino or Adrian Scott Norton, it doesn't apply and it doesn't work. With respect to providers like Dr. Nitta or FNI, his business, it doesn't work. They're all unconscionable. It is all one-sided. And let me give you a specific example, if I may. In terms of Ms. Orsino, she was seen by Dr. Nitta on January 25th of 221. That's on the third amended complaint, docket 104, paragraph 66. She delivered her premature baby on February 7th, 2021, which is docket 158 at paragraph 20. And then 2 weeks after that, HMSA sends her a notice of denial for the prescription that Dr. Nitta made to her back in January. And how is this fair? How is this balanced?
So this is the question right before us, which is, should a trial court like the Third Circuit simply invalidate all of these 5 contracts that HMSA has with the various providers and or with the claimants? Or should your particular claims for damages with these circumstances that are highly unfortunate, but for the damage claim, not for the particular treatment, should those go to an arbitrator? That's the question before us, right? And so that's why we keep coming back to, is the arbitration provision unconscionable as opposed to the entire contract, which I know you want to litigate. I know that's the gist of what your larger claims are, your larger lawsuit is. The question before us is, should it be decided by an arbitrator, or should it be decided by the court below, which invalidated the entire contracts?
With all due respect, I disagree, Justice Ganoza. I disagree because when the court in 3 of the cases, Gabriel, Narayan, Siopis, when the court points to the restatement second on contracts, section 208, which says that a contract or its terms can be invalidated or ruled by a court to be unenforceable, I take it as the black and white.
That the entire contract. That's where you're talking about the entire contract.
That's correct. And 208 of the restatement second on contracts does say in the second factor that the court can actually sever the unconscionable provisions. But we're submitting that when you have unconscionability that is substantive, that infects the entire agreements or the entire contracts, that you have to strike it down. There's no alternative. And I would want to point out in the few minutes I have left
Thank you.
is that, you know, understand the parade of horribles. They brought it up before, HMSA brought it up before and says, okay, if you're going to strike these whole contracts or take out these arbitration clauses, you know, the parade of horribles, all these things are going to go on, and, you know, HMSA is going to have all these plethora of claims, and it's going to be unenforceable, and people's health care is going to be substantially affected. And I would point out again, that is not supported by the record. And in terms of severability, I would caution the court against severability and carving out the arbitration agreements, because that would be, and I'm going to quote Star Wars, that would make HMSA the ultimate force in the universe, meaning that HMSA, by having the arbitration clauses carved out, would be able to basically say, okay, every month that ends in Y, we're not going to pay any claims. I mean, it could be as arbitrary as that. And no claims would be paid. No physician, no individual could actually get HMSA or before an arbitrator or anybody else to determine whether or not those claims could be paid. So we submit, given the circumstances, you have to look at this from the broader perspective and invalidate or find that these agreements are unenforceable in terms of whether they violated public policy, which we lay out in our briefs, which there was also what we feel is moral turpitude, serious moral turpitude, as the court pointed out, as Justice McKenna pointed out, citing the beneficial case. And also, in terms of the language itself, we feel that these contracts are completely unenforceable. I have a few minutes left. I'd be happy to answer any of the questions that the justices may have. Seeing none, I just want to say finally, to quote the great Peter Esser, my mentor and friend, I just wanted to thank the Chief Justice for his service to the people of the state of Hawaii and the judiciary. Thank you.
All right, thank you, Mr. Hong. For those of you who don't know, I'll be retiring at the end of September. I think that's what Mr. Hong was referring to. Mr. Wadoff, a couple minutes, if you could keep it to that.
Thank you, and I'll try to be brief and only respond to issues that came up with this most recent argument. What I did want to address immediately and put to bed is this idea that HMSA somehow has unilateral ability to select the arbitrators. During the break, we did go back and confirm with dockets 142, 43, 44, and 45. In every single one of these agreements, the arbitrator is mutually selected. If the parties are not able to agree on an arbitrator, it either goes to the DPR process or it goes to the circuit court to take.
So how does that create an expedited process if the party has to go to a circuit court to get an arbitrator appointed? And how is that fair? Because if you're an individual, if you are a corporate physician, you have to hire a lawyer to go to court because you can't appear on your own. You have to have an attorney go to court, and you have to explain what the situation is. It takes a lot of time and a lot of money to get an arbitrator appointed.
To answer your question, Your Honor, I think there always has to be some safety valve out there if the parties can't agree to a mutually selected one. I think the DPR process is very quick. Going to court perhaps takes a little bit longer. But in practice, every one of these arbitrations that I've participated in, the parties have been able to select a mutually agreeable arbitrator. One of the incredible things about practicing law in Hawaii is that we have a bar where folks know each other, know who the potential arbitrators are, and are able to select arbitrators in an efficient process. That issue, I have never seen it be a problem in any of these cases that have ever come up, Your Honor.
Mr. Wadoff, what's your response to Mr. Hong's argument? And I asked him this question, I'll ask you as well. We have two very different characterizations of the negotiation process. On Mr. Hong's side, doctors who submitted declarations that HMSA has really no interest whatsoever in negotiating and doesn't negotiate. And again, I'll limit it to the arbitration context. And on your side, there's this, the notion that HMSA talks to or discusses these issues with the Hawaii Medical Association and then sends comments out for comment. Is this something we can address as a matter of law? Is further factual development needed, or what's your take?
Two responses to that, Your Honor. First, I would respectfully disagree with my colleague that there isn't information about this in the record on appeal. We submitted numerous declarations, most prominently at docket 200 and docket 201, from a number of individuals at HMSA that describe this process in detail, that attach exhibits like the notice that went to FNI to comment on this. We also have an amicus brief from HMA itself that describes this process. HMA describes how in a previous situation where it believed that a term was not sufficiently fair to providers, it provided an objection, and thereafter HMSA changed the agreement to address that objection. So I think that there's a plethora of information about that in the record and appeal and in the amicus brief that was submitted by HMA. But I think that there's maybe an even easier way to deal with this, Your Honor, and that is that the cases have recognized that even if this was a contract of adhesion, adhesiveness by itself is not sufficient to determine agreement to be unconscionable.
Okay, along those lines, I do have a question regarding the provider agreement, which I noticed, and the arbitration clause, section 8.2 says, shall be resolved by binding arbitration as set forth in this agreement unless arbitration is waived pursuant to section 4.8 of this agreement. And I had earlier asked because docket 143 is not actually a complete version of the provider agreement, despite the declaration saying that it was. So in docket 201, when I look at the complete 4.8, waived pursuant to 4.8, 4.8 relates to refunds, and it says that if there's an overpayment, the physician has to repay it, and if the physician doesn't repay it, and it goes to a collection agency, the physician waives the right to arbitration. What does that mean?
Respectfully, Your Honor, that was not an issue that was raised at any point during this case.
I'm just curious, what does that mean?
I don't know that I could answer that without spending a little bit of time with the document and giving you a correct analysis of that. This collections issue is not something that's ever come up in this case, and does not, I don't believe it has any relevance to the issues that are raised in this complaint.
So this court cannot look at the arbitration clause in totality to address unconscionability. We can only address issues of unconscionability that were raised. That is your position, right?
That's correct, Your Honor.
Thank you.
There's de novo review, and it can look at all of the issues that were raised in the lower court.
Aren't we supposed to summarily decide? So I see. It's de novo. So we can't, if the circuit court had noticed provisions, had looked at different provisions and had ruled on, and the circuit court could address them even if they weren't argued? It's summarily decide, right? On SJ, it's kind of like an SJ process, right?
It is, Your Honor, and I believe the Safeway case, it's an ICA case, but it addresses that to some extent. And I think what ultimately controls is whether there's disputed issues of material fact that would be relevant to the analysis. And in those situations, Safeway suggests that a evidentiary hearing before the circuit court is the appropriate avenue to pursue. I don't think we need to go down that road here because I think that there's more than sufficient information to resolve this. And one of the points that I wanted to highlight on that is on this issue of potential procedural unconscionability. Again, we believe there's this very robust process out there with HMA, with the draft notices to providers. But even if that didn't exist, then we would look to substantive unconscionability. There would have to be substantive unconscionability here. And these arbitration provisions are not substantively unconscionable. There's no confidentiality provision that keeps these secret. There's some limits on discovery, but they're the type of limits on discovery that numerous courts have upheld. They allow for document production. They allow for depositions. There's no unilateral selection of arbitrators. the results are binding on all parties. These are the types of arbitration provisions that are vanilla and do not give one side any advantage over the other side. So all of these issues about the procedural process ultimately are not relevant to the analysis because there's no substantive unconscionability.
So it is your position that we would have to uphold the punitive damages clause that if we have ruled in Narayan, which I believe we have, that these are unconscionable, invalid, we can't address it?
No, in Narayan, Your Honor, the court addressed the issue of whether severability is available to address an arbitration provision. And the court determined in Narayan because in addition to the clause regarding punitive damages, there were a number of other problematic clauses, and it essentially said, look, they're too interwoven in this situation. We can't just strike the punitive damages clause. There would be other problematic clauses here. That's not the case here. That one sentence about punitive damages is really the only thing that one could find to critique about these arbitration provisions. And so if the court does believe that an arbitration provision that contains a punitive damages limitation is unconscionable, then that one sentence can be stricken from this arbitration provision without impacting any other aspects of the arbitration provision. It's exactly the type of situation that severability was designed to address.
Very well. Anything further for the court at this time?
No, thank you, Your Honors, and I appreciate the additional time.
Very well. Thank you to both of our attorneys for your arguments today. The court will take this matter under advisement.
Please rise. Ua ho'oku'u ia mai nei kea aha ho'okolokolo ki'iki hanohano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.